Good evening. One of the oldest supposed guarantees of the fundamental rights of free citizens against the encroachments of government is the guarantee of an indictment by a grand jury, an institution which grew out of the common law and antedated the American Constitution by some 600 years. The grand jury was founded as a protection of the individual against arbitrary indictment or intimidation by unscrupulous prosecutors. It was the grand jury which twice refused to indict John Peter Zenger in colonial times for seditious libel against the royal governor. Following the colonial experience, the grand jury was considered of such critical importance as a protection of the rights of free men to be written into the Fifth Amendment as a protection of citizens in federal criminal procedure. As has been pointed out many times, the effectiveness of the grand jury has always been dependent on its independence from those in authority. Yet just 2 years after the adoption of the Bill of Rights, Thomas Jefferson was charging that the Federalist Party was transforming grand juries from a legal to a political engine by inviting them to become inquisitors on the freedom of speech. In the past 3 years, increasing use has been made of federal grand juries as engines of those in authority in assorted fishing expeditions into private lives and information of a number of people, a fact which has led Charles Goodell in the current issue of Harper's to conclude that the grand jury is again in the hands of unscrupulous public authority. The most widely publicized of these instances centered on the facts attendant to 3 companion cases settled by a 5-4 vote of the United States Supreme Court last June, upholding the right of a grand jury to request the names of confidential sources of information of newspapermen in their reportorial investigation of matters which grand juries may then or later have under investigation. A storm of investigation and discussion and proposed legislation has ensued, including hearings in Senator Ervin's subcommittee on constitutional rights last March. The problem has not stopped with newspapermen, however, but has affected a number of private citizens. Our guest this evening is one of those citizens. Last November 21st, Professor Samuel Popkin was put in jail for his refusal to answer questions put to him by the prosecutor in a federal grand jury proceeding in the city of Boston. Although the story is his to tell, press accounts indicate that Professor Popkin's connection with the proceedings amounted to no more than his having been a friend of Daniel Ellsberg's and having developed a research and teaching interest in Vietnamese village life. It is the first time to anybody's knowledge that a member of the academic profession has been jailed for refusal to answer a grand jury's questions, and his case was argued on the last day of the proceedings by the president of Harvard himself. Professor Popkin is an assistant professor and lecturer in government at Harvard. He is a native of Superior, Wisconsin, and did his undergraduate work at MIT. The holder of a Woodrow Wilson Fellowship, he completed his doctorate at Harvard, where he now teaches statistical methods of political analysis and a graduate seminar on the politics of Vietnam. Professor Popkin appears this evening under the sponsorship of the Department of Journalism as a part of a 3-day set of symposia on the press and the grand jury, the University Lectures Committee, and the University Committee on Pre-Legal Education as its annual observance of Law Day. Those of us who have been with him through certain parts of this day have found him a personal pure delight. Professor Popkin, it is a privilege to welcome you to a state whose faith we like to think is still embodied in its motto, "Our liberties we prize and our rights we will maintain," and to welcome you to this campus. Sam Popkin.
Thank you. I It's always just a little bit uncomfortable to be applauded for having gone to jail. It somehow it never sits right, no matter how many times I speak to people, that somehow courage is part of the requirement for being a good scholar or a good reporter. And I somehow think, a little bit wistfully about the days when universities could simply hire their professors on the basis of whether they published, perished, or were good teachers, or were, delights during the day, and not any worries about, are they tough enough to go to jail to do their work? But this is the big issue now, and when you get involved in a case like this, like I did, and I'll talk about it, you really begin to take seriously again the whole Bill of Rights and start to think about where it came from and why it's there and what it meant. And especially the code by which you do your research and your teaching, something you just always had taken for granted and had never thought about until you realize that you can be put in jail unless you compromise your own integrity. Now, I want to talk specifically about one part of the problem that's facing so many journalists and academic researchers today. Most of the talk is about shield laws, and most of the blame for everything is focused on one or two men in Washington, usually President Nixon and Vice President Agnew. Let me just take a little different tack, not in any way denying the role of the White House in starting this whole caper, and not denying the importance of some form of shield law, but I want to talk about two other sides of the problem that really get ignored a lot. One is the grand jury, which I've come to know and hate, and I must say, even though those guys put me in jail, and I get a certain kind of very fiendish personal pleasure when I see them come out of the grand jury room, I don't even think, after what I've gone through for 2 years, that anybody should have to face the kind of a barbarous institution, not even the Mitchells and the Magruders and the Haldemans, who had so much fun doing it to me when they thought I was just some bum at Harvard that they could score points by beating up. I don't think at all that it makes sense in America to say the problem is one man, it's just the tone of the White House. And I don't think it makes sense to say the solution is only to establish absolute or limited shields to protect a very narrow class of people. That's all part of the problem, but I think in a much broader sense, a very large part of the problem facing us is to think about reform of the whole grand jury system. And what I want to do is really give you a sense of what grand juries are like and how they operate. And I see an analogy today between grand juries and the issue of law and order on one hand, and congressional committees and Senator McCarthy in the 50s and the problem of communism. In the 50s, people had a very true, a very serious, and a very rational concern with the problem of Russia, Stalin, and communism. But the way we overreacted against this problem for decades stifled and paralyzed our ability to talk freely about foreign policy. There was an extraordinary chill in the country because any professor who was a specialist in Asian affairs or international relations knew in the 50s that even to say certain things about China or about Vietnam when it first became a problem meant that this man could be harassed by the FBI, that this man would be called in front of congressional committees, that his integrity would be questioned. There was just a kind of a chill in the air it was just a total chill on our ability to talk about a lot of these issues for a long time. And today, again, I'm worried that we may be losing our sense of balance. It's not Congress and congressional committees this time. This time, I think the grand jury might be the instrument, and with the grand jury as the instrument, I'm very concerned that the ability of scholars and journalists to provide us all with the kinds of information we need in a democracy may again be threatened. And there are a lot of cases, by no means is mine the only one, that demonstrate that there's a need for much greater sensitivity in courts and in government and among the public, among us all, about the ways in which we get information about what's going on in the country, especially how important it is in the past and in the present that reporters and some scholars are able to talk in confidence with government officials and other people. There's so much that we know about government today that we only know because a reporter guaranteed the confidentiality of a source of some of his information so that man wouldn't be fired by his boss. Or some scholar even did something as trivial as a large-scale survey where he guaranteed the people in the public opinion poll that he was conducting anonymity. Or somebody did a study of federal bureaucracies and was allowed to observe how the bureaucracy worked because he guaranteed he wouldn't name anybody. And so much of what we know about government, confidential sources are essential, or we wouldn't have the information we do. And if people, scholars and journalists, cannot talk in confidence with officials, we'll still have a First Amendment, but all it will do is protect polemics and handouts. A crucial aspect, then, of the problem today is to prevent grand juries from being consciously abused and manipulated to censor the news flow. The House Un-American Activities Committee and other bodies like it are no longer the menace in the Star Chamber they once were, because the courts and Congress have slowly and ploddingly delimited procedures which keep them in check and prevent at least many of the worst abuses. But grand juries have become more and not less fearsome in the last few years, and it explicitly goes to the Caldwell decision handed down by the Supreme Court I guess it was almost a year ago now. This is almost within a month of when the Caldwell decision was handed down. And the decision is always called the Caldwell decision, but the key part of the decision really has to do with a reporter from Louisville, Kentucky named Paul Brandsburg. Paul Brandsburg, in effect, went underground for a while in the local counterculture of Kentucky. Even in Kentucky, there's a counterculture. And wrote a lot of stories about what was going on in the drug scene. And one of his articles was about the drug trade in Kentucky. And with the article in the paper, there was a picture of a few people taking stems and twigs and seeds and second-rate marijuana and making hash from it. And there were no faces in the picture, just hands, test tubes, Bunsen burners. It could have been anybody's chem lab, actually. And Brandsburg was called in front of a state grand jury and asked to identify the people in the picture. And he refused, and he made a very important argument. I'm of course not doing justice to it, but it's a key argument. He said, in effect, I only know about this crime that I witnessed because I promised not to reveal the identity of the people involved. If you make me tell you their names, you'll get them, but the public will never hear about what's going on in their state again as fully because I'll never be able to do another story like that again. You can censor me and stop me from embarrassing you on this one story by making me give you the names, but the public is the loser. And that's what the First Amendment protects. It doesn't protect the right of Brandsburg to make the front page and get a $50 bonus because he had a great expose on drugs. It protects the right of all of us to be informed and so that we can make the decisions we're supposed to make in a democracy. But the Supreme Court decision in these cases, one involving Caldwell from the New York Times, one involving Brandsburg, and one involving a TV journalist from Massachusetts, explicitly stated that any reporter, any scholar, any journalist, what have you, must answer all relevant and material questions asked of them by any grand jury. And this was not a political decision. This is one of the reasons it's important to realize things wouldn't be that different if we had the old Warren Court, because the minority opinion wouldn't have got people out of trouble. And it's important to realize that this wasn't a political thing that the court was put up to by Richard Nixon to stifle political dissent, although it has that great value. This was a pure law and order decision. What the Supreme Court was saying was that today's crime is more important than tomorrow's news. What Justice White, a Kennedy appointee, said in the key, frightening to me sentence of the whole, what we call opinion, was, we cannot adhere to the view that it is better to write about crime than to do something about it. Now, when they said that everybody must answer all relevant questions, they just didn't recognize some of the problems with grand juries. They gave no guidance as to what was relevant and what wasn't relevant, and the Supreme Court gave little, in fact, no recognition to the kinds of abuses for which grand juries have been used. And the examples are legion. All over the country, when Guy Goodwin was in the Attorney General's office with Robert Marty and as his boss, there were special grand juries set up in out-of-the-way places. And any time the Justice Department wanted intelligence data on any kind of radical or opposition group in any kind of peace movement, from moderate peace movement to very, very radical peace movement, they simply called a grand jury, told the judge they were investigating some possible conspiracy or other, and then called in every radical within hundreds of miles and asked them questions like, tell me every time you've ever crossed a state line to talk about such and such, or tell me every person who visited your commune in the last year and what was the subject of conversation, and just some rather extraordinary questions. And the grand jury has become more frightening because of recent decisions in the laws passed by Congress in the last few years, which have extended the power to grant immunity, which have made it easier to do wiretapping, and above all, all these laws were passed because of this pervasive mass concern we have about crime that makes anybody who ever refuses to answer a question look like they are protecting crime. That's a very big part of the atmosphere for a long time that made it easy for people like Brandsburg and places like Kentucky to have so much dirt thrown at them by prosecutors. Now, the key thing about a grand jury that makes it this perfect instrument for torture is the fact that the grand jury, through its prosecutor, has the right to get any judge to give you what's called immunity. And without going into the details, anytime any FBI agent or any policeman or anybody comes to you and says, I want information from you about anything, you have the right to take the Fifth Amendment and say, I refuse to answer on the grounds that it may incriminate myself. Okay, one of the few ways to get around the Fifth Amendment we have is the grand jury. You call somebody into a grand jury and they say, I don't want to talk to you because it'll jeopardize something or other, so they take the Fifth Amendment. But a grand jury can give immunity. Immunity means the prosecutor who's running the grand jury goes to the judge and says, Judge, we want him to talk, we don't want him to be able to take the Fifth. So that he cannot incriminate himself, we promise we'll never prosecute him. And that's what immunity in effect means. It means your evidence will not be used against yourself, or that you even will not be prosecuted sometimes for the crimes discussed. So that to a very large extent, you have no justification anymore for taking the Fifth Amendment. And once the Fifth Amendment has been stripped from you, you either answer all questions which you are asked, or the judge will put you in jail at the prosecutor's request. The First Amendment, in other words, is not recognized as a valid reason to refuse to give information to a fishing expedition being conducted by any DA or Attorney General or anybody, any U.S. federal attorney. And even though these days we're getting an awful lot out of the newspapers about Watergate and about all the political sabotage, we really are suffering some of the effects of these decisions that limit the reporters. All that we're getting right now comes out of one of the maybe no more than 15 or 20 papers in America, the Washington Post, that has the money and the guts and the power to be willing to back up their reporters so that they can do the story and be willing to accept jail. There are a lot of reporters who aren't willing to take the chance, and I'm sure in small towns all over America, there are a lot of editors who aren't willing to get mixed up in such a dirty business from their point of view. Take an example from my own backyard. One of the toughest, best newspapers in New England now is the Boston Globe. For a few years, they've been running a very, very hard-hitting series called the Spotlight Series, where they send a team of reporters into some little local burg, and the reporters do a really good job of finding out how the assessing process works or how the payoff scheme on education contracts works. And in several cases, they've thrown out mayors through this series, elected reformist governments, and even cut people's taxes in one case by as much as 10% on their property, just because the corruption was stopped. Okay, there were 6 reporters on the Spotlight team. 2 of the reporters have asked to be removed from the series because they feel that they're too old to risk a sentence in jail to protect their informants. They simply said they're not sure they can take a jail sentence, so they'd rather have a different assignment. And some of the people in the city of Boston that the Spotlight team have worked with now refuse to talk to them because they themselves say they're not sure that the reporters will go to jail, and they can't take a chance on losing their job just to promote the civic good and better, societal conditions in the greater Boston area. There are even academic examples. There are people who are doing studies of police corruption or police methods who are very concerned about how much they're going to be able to publish without being called into court. There's one large university where they do a lot of social surveys, public opinion polls, where you go around and ask people detailed questions about a variety of topics. They used to keep the questionnaires for 10 years after the study was over in case anybody wanted to go back to the same people 10 years later and do a second investigation of how things had changed. Now they burn the questionnaires the minute they're coded so that they never have to worry about being called into court and asked, give us the name of every person who admitted adultery, because adultery is a crime in this state. Or give us the name of every student you interviewed who said that they'd ever tried marijuana, because using marijuana is a crime in this state. They're not able to take the chances. They burn the questionnaires. The government isn't going to, benefit by this, but we're all going to lose something just because they're doing things properly and ethically now. So I'm very concerned that people understand the key role of the grand jury in this whole business. More than 35 reporters have been in jail, and I guess so far just one scholar. And maybe it'll be over with Watergate, but it's really too soon to say, and I don't think so, because now most of the jail sentences come out of state and local government, not out of the federal government. In almost all of these cases, with a very few exceptions, I think maybe all but 4 or 5 of these almost 40 cases have involved grand juries. Now, nobody should be surprised when a government tries to censor the news. There's nothing fiendish about that, I don't think. It seems to me that every government has a very understandable and a very threatening interest in controlling the flow of news to the public. I don't think anybody should be surprised when somebody on the White House staff or the head of an agency or a police chief or a mayor or even a cabinet member doesn't want anybody who works for him to talk to the press or to let out any information. There's nothing surprising about that. But that doesn't mean people like that should be able to use the grand jury system to find out who talked. And that's now very easy. What better way is there for a corrupt local government or a national government to keep certain kinds of information from the public than to use the pretext of a grand jury investigation of a crime? You set up a grand jury, you say you're investigating a crime, you call in somebody like myself or a reporter, and you ask them questions that would elicit information about their sources, questions that go, say, far beyond anything that would be needed in a legitimate investigation of a crime. These huge powers of grand juries make them the perfect way to find out who the honest policeman is that talked to a reporter. Or even, in my case, who are the people in the Army and the State Department that I'd been interviewing for the last 7 years in the course of my research for a book on Vietnam. It's very easy to do. A reporter writes a story in the paper about some local corruption, and the story embarrasses the hell out of the local government. So they call a grand jury, and they say they're investigating crime, and they say, oh, we've been prompted by the press to do a better job than we've done in the past. They call in the reporter and say, okay, tell us who gave you all your information. And the reporter says, I'm not going to tell you because all you want to do is fire the guy. And the prosecutor goes to the judge and says, oh, no, we don't want to fire anybody. We just want to find out where he got the information so that we can go out and ask him to name people for us. And of course, then afterwards, it's very likely people are going to get fired, but it's too late for you to do anything about it. And you're faced with the choice of either answering the questions or, in my case, having no choice, I felt, but to go to jail to protect my own integrity. Now, let me talk a little bit about what it's like to appear in front of a grand jury, because it's about as close to torture as people come today in America. And there was a time when people would take you and they'd put you on the rack or they'd put you on a thumb screw and they'd tighten it a little bit until you gave and you talked. They don't do that anymore. Now they put you in the grand jury room, and if you don't break there, they put you in prison and wait for somebody to beat you up or molest you or whatever, so you can't take it any longer, and then you'll talk. And by the way, I was very lucky. I got probably the only neat, clean, well-fed jail in New England, so at least I didn't have any problems with jail the way I was afraid for a year and a half. Let me talk a little about the grand jury, and if anybody doubts any of this, let me say that every single thing I am mentioning now, because my transcript, so much of it got into the court record during a year and a half of legal battles, anything I'm saying can be checked very easily in the actual court record, so there's no question of my embellishing any of this unnecessarily. I was even out of, by the way, just for background, I've been doing this book on Vietnam for years and years, and I am a friend of Daniel Ellsberg's. We met because we had similar scholarly interests in Vietnam. We were both doing books on Vietnam. I got to know him when I went to interview him, because he was an extremely important, powerful policymaker in Vietnam when he was there. And then for a year when he was living in Cambridge, we talked quite frequently about Vietnam, talked about all sorts of subjects related to Vietnam, mostly when I would go to interview him because I needed information from him for the work I was doing. I was out of the country, however, when the Pentagon Papers were released. It caught me totally by surprise like everybody else. Simply, nobody had asked me to help with the thing. Nobody had asked me to take part of it. I guess I was a little miffed at first because I thought it would have been neat, but I just had, I had zero to do with it. Not that I'm above doing things like that, I just wasn't asked. So I came home from visiting my fiance and going to an international conference, and the FBI came and visited me. And I now realize that what they were looking for, a lot of it. They were asking me a lot of questions. Did I know the names of Ellsberg's psychiatrists? What did I know about his personal life? Was he shaky? Was he erratic? Was he emotional? Was he unstable? Just all sorts of funny questions, which I didn't answer because they clearly had nothing to do with the investigation. This is, by the way, exactly 1 week before the break-in in Los Angeles. Then they started asking me all sorts of questions about, did I know Ellsberg did it? Did I know who had the Pentagon Papers? Had I ever seen them? Had I heard anybody talking about it? And it's very intimidating when the FBI comes to see you. You don't know you're supposed to go get a lawyer so that there's a record of what you say to them. You get very terrorized into talking the way they approach you and say, oh, you don't want to talk to us, what are you hiding? So you cooperate. And I answered all their questions fully then, because I had, in fact, zero information. And I said, no, I don't know anything about this. No, I don't know anything about that. And it just went on for an hour and a half. These two guys, one guy sits and guns 10 questions in a row at you. Then the other guy pops one in from the other side where you can't see him when he thinks he's going to catch you. And this went on for a while. And I thought that was the end of it, because clearly I didn't have any information. And that would be they'd go away and go pick on somebody else. Then one day I got a subpoena to appear in front of a federal grand jury. And I said, uh-oh, what's going on here? The first thing that you realize is you look at your subpoena to find out what they want from you, and all the subpoena says is you are directed to appear in the matter of, and then it's typed in, the United States versus John Doe. Yeah. That's it. That's all you get. Now, obviously, there were First Amendment issues involved here right away, because it was clear by the time I got the subpoena that there was all sorts of dragnetting going on over the Pentagon Papers, and that the government was starting to panic about leaks. There was something about the SALT talks that got into the New York Times, and there were lie detector tests being given in the State Department. And so, for not exactly irrational or paranoid reasons, I thought, they may have decided to pick on me and find out everybody I talked to. And although I certainly knew nothing about the Pentagon Papers, I knew where an awful lot of other bodies were buried, and I knew an awful lot about what was going on in Vietnam and in Washington, and I had an awful lot of people who had trusted me and talked to me, both in the State Department and in the armed forces. And I was very worried. So I got myself a good constitutional lawyer, and we went into court, and we filed a motion requesting the judge to force the prosecutor to tell us the subject of the investigation. Because when you go into court, all you can find out is you find out that the prosecutor is impaneled to have a grand jury. So you say, well, we'll find out what the grand jury is about. And you find out that the grand jury is empowered to investigate interstate theft, interstate transportation of stolen property, numerous conspiracies, and espionage. And that's all you know. And you don't know if they're after you, or they're after people you know that you're going to tell them about, or they're after Ellsberg, or they're after the Boston Globe or the New York Times. They say nothing. And I guess I was even the first person to get a subpoena. So we go into court and we file a motion to ask the prosecutor to tell what's going on, claiming that since our First Amendment rights might be in jeopardy, since this was clearly related to my research and I was publishing and the public would be heard, we needed some information. And the judge had no choice but to rule against me on the And the judge had no choice but to rule against me on the grounds that the way the law was set up, I had no right to know any of this, but that at a future time, these considerations might become relevant. Well, that meant to keep a good record, every time I went in front of the grand jury, I had to say, what's the subject of the investigation? And one of the great educations you get is actually appearing in front of a grand jury. The grand jury room is about the size of this front part of the auditorium, from the first row of chairs to this green panel and back and forth. And there are 23 citizens chosen from the federal voting list sitting there. There's a stenographer who takes down every word anybody says, and there's a prosecutor. There is no judge, and you are not allowed to have a lawyer in the room with you. You enter this room, and it really is very intimidating, because you sit in this big high chair and you take an oath, and then the prosecutor has to read you a statement about, do you have a lawyer, do you know all your rights? And you couldn't understand the statement without having a lawyer there, so you don't even know what you're agreeing to, except I knew what the statement was in advance, and I knew what I was supposed to say when he read it. And then, as I had to do for the record, as the prosecutor knew, because he'd just been in court with me, I said, before we go any farther, sir, and I had a clean haircut. I was very proper. I wasn't about to play any unnecessary games to irritate anybody. I said, could you please tell me the subject under investigation? The prosecutor looks at me, and he looks at the grand jury, and he says, Mr. Popkin, you've already kept these good citizens waiting for over an hour while you stalled and delayed in the courtroom. You know the judge directed you to come here and answer our questions. Please don't have any more delaying tactics. Let's get right down to business. And already, before I've even said a word, an image of me is being planted in the minds of these citizens. Now, they're supposed to be, in the colonial days, those 23 people were not just 23 retired clerks picked at random or something. This was sort of the local elite to sitting there to make sure the federal elite didn't pound on anybody's heads. Now it's different. This whole thing is a tool of the prosecutor, whoever he is. Then they ask me, and the secrecy protects the prosecutor and lets him get away with all this. It doesn't protect the witnesses the way it's supposed to. Then they asked me the first question. The first question was, do you read the New York Times? Okay? The most straightforward possible question. Nothing but the most elementary setting out of the background of getting down to brass tacks on maybe even a legitimate investigation. Who knows? Maybe they really were onto something, important, like tax evasion or white-collar crime. I mean, I didn't know. Okay, you can't answer that question. You have to take the Fifth Amendment. And let me explain why. If you don't want, when I walked in there, for all I knew, they were after me on a conspiracy charge to try and prove to the Arizona right wing that Harvard was really behind this and they were going to clamp down Harvard and everything was going to be great. You don't know. And one of the most upsetting things about this whole process is you never give anybody the benefit of a doubt, because if you do, you're dead. It's not like you can wait until they cross you and then fight back. You have to play tight from the beginning or it's too late. And taking the Fifth Amendment on a trivial question like you read the New York Times is a classic example. Because I was worried about being hooked on a conspiracy charge, possibly, because you never know what's in the minds of those guys. I mean, I couldn't tell what was going on. And I mean, I had no idea what was going on. After all, the Chicago 7 didn't even know each other. For all I knew, this was going to be the Ellsberg 12. I mean, and it is even conceivable in somebody's deranged mind that once upon a time I read an article by Dan Ellsberg and I said, Dan, that's a great article. You ought to publish it. And that could have been a conspiracy to commit espionage. You don't know. So the first thing you do is you cover your rear. You make sure they give you immunity before you open your mouth. And why did I have to take a fifth on that trivial question? Because the law says something very complicated that I've never yet understood about links in a chain. And in effect, what goes on is, if you answer a question without invoking the Fifth Amendment, you then must answer all the questions that are links in a chain with that question. So I could have said, yes, I read the New York Times, and they can say, tell me the name of every secret source ever quoted in the New York Times. And then I couldn't take the fifth, or whatever. You just don't take any chances. So I take the Fifth Amendment for the most obvious reasons known to all lawyers on a trivial question. And the prosecutor knew why I was doing it. There's no secret. So he turns to the grand jury, and he says, oh, you're taking the Fifth Amendment on that question, are you? And you're sitting there, before you've said a word, just doing things automatically the way they're supposed to be done, the way they have to be done, the way the system requires it of the most well-meaning person. I'm already being painted as a troublemaker and a smartass and a bad guy to this grand jury, who, remember, is supposedly there to decide whether or not there is enough evidence to bring charges against somebody and get them in court on what could be $1 million 2-year trial. And it goes on like that. Finally, they gave me immunity, which meant at least I didn't have to worry about getting myself hooked on a conspiracy charge. But I could never find out. We'd keep saying to them, what is it you think I know? I really don't know anything. If you're really just doing a narrow investigation of what went on with Ellsberg, you can let me go, because even if I wanted to obstruct you because I admire him, I couldn't, because I don't know anything. So I don't even have to be in the position of pulling a Gandhi and say, I'm going to jail for my great friend. I couldn't go to jail for him if I wanted to. I mean, I just don't know anything. But we could never find out what it is. They'd say, you'll find out, answer our questions, and we'll be done with you. And I'd say, but what is it you want from me? And they don't tell you. And that's when it starts to get very frightening going through this. If you've read Darkness at Noon, you have a sense of what it's like. They're bad guys. But it's hard to believe they're just thick and stupid. You tend to think, because they come into court with these big briefcases and they fly around the country and they really seem to know what they're doing, that they're very smart and everything is well planned. And when you assume they're smart and they're well planned and they're taking a lot of their time with you, you assume there's a reason for it. Therefore, if there's a reason for it, that must mean I know something. But I don't know what it is I know. So you sit there racking your brain saying, is there something they know that I forgot that I know, and that when I say I forgot it, they're going to put me in jail for perjury for 10 years? No, it gets to be very frightening, because you don't know if they're playing straight or if they're playing crooked. So you can be terribly afraid of saying no to something where they've got, say, a wiretap that proves the opposite, and then they'll indict you on a perjury count. Now, clearly, in a case like that, they could never, ever make a perjury count stick. But imagine how it looks if somebody says, you know, I am taking the First Amendment to protect the public's right to know, that I am protecting my sources, that this is a very clean, straight, narrow First Amendment case, and then 3 days later you read in the paper that I was indicted for perjury. You know, the government can get a lot of points out of that. You don't know if that's what they're up to or not. So one day I thought I had a chance to find out, because all of a sudden they asked a question that seemed to have a lot to do with conversations with Dan Ellsberg, kind of a thing that might have come up in conversations. And I said, aha, maybe they were tapping him, because it appears that they've been after him for a long time before he released the papers. Maybe they were tapping him, and we had a conversation one day, and the word paper, or the word documents, or the word secret came up, and not knowing any better, they assume there's only one secret document or one paper in the whole world, and that's the one they're investigating. So I really know something, and I'm hiding it from them. And if we could find out the transcript of whatever their taps they've got, then I could say, this is a complete misunderstanding. Goodbye, I'm going home. I don't want to be a Harvard hero and take your time, and I'd just rather go back to work. So they asked me a question, and I said, I take the Fourth Amendment. The prosecutor said, why do you take the Fourth Amendment? And I said, well, to guard against unlawful search and surveillance. And he said, you mean electronic eavesdropping? And I said, more or less, yeah. And he looks at the grand jury, and he looks at me, and he says, oh, you mean if we had been overhearing you, we would have heard something incriminating? You know, this is before I've done anything yet. You know, all I had done so far was testify that I had never seen the Pentagon Papers. I testified I had never seen them. I testified nobody had ever told me they had them, that nobody had ever told me how they were distributed, and that nobody had ever told me they were going to be distributed. So I kept saying, even within the toughest kind of framework, I've answered the relevant questions, and you shouldn't make me go any further. And this was an approach I had worked out before the Supreme Court had handed down the Caldwell decision. I had assumed that they weren't going to let people out of testifying, that they were going to say you have to answer relevant questions. So we try to work out our own definition of relevant. Now, some reporters and some scholars are going to know about crime and aren't going to be able to testify because they're writing about crime. Like they're writing about, well, things that are called crimes, you know, drugs, gambling, prostitution, you never know what. And they're going to have to, you know, not even answer relevant questions in the legal context. But I didn't have that problem. I could finesse that whole issue. But I just couldn't answer a lot of these way out questions that they finally asked me. And some of them finally got thrown out. One question, for example, they asked me that got thrown out, that is example of what they can do with a grand jury to you if you don't come from Harvard and have good lawyers and a lot of people raising money to help pay your bills. One of the questions they asked me was, name every person you interviewed in the course of forming your opinions as to who wrote the Pentagon Papers. Get that? Name all the people you interviewed in the course of forming your opinions as to who wrote the Pentagon Papers. Now, you know, given the way lawyers' minds work, a lawyer can show you a way that at only 7 steps removed logically that is perhaps relevant to an investigation of a crime. Perhaps, someday. But that question is 100% relevant to censorship if what you're really trying to do is find out everybody that talks to anybody writing a book about Vietnam, even if that person is not an activist, and even if that person, by campus standards, is not even radical. They can still do this to you. I mean, here's this grand jury that's supposed to be sitting there to protect people, to make sure there's not an unfair indictment, and hear evidence, and they're being manipulated before I even open my mouth. The foreman, technically, is supposed to run the grand jury and decide what goes on. The only time the foreman in my grand jury ever opened his mouth was when the prosecutor winked at him. I'd say, Mr. Foreman, I request permission to see my lawyer. The prosecutor would either wink or say, Mr. Foreman, you may give him permission. I mean, there wasn't even a pretext in that room of who was in charge. They didn't even make a facade of it. It was just blatant and out in the open who was running this show, whatever show it was. You know, and even this business of, okay, you know, I'm used to giving oral exams and taking oral exams and giving the gas to students, so I'm used to this kind of very tough, mean, hard verbal interchange. But imagine what it's like if you don't have a lawyer, or if you haven't been, steeling yourself for days to go through with this process. And all I was doing was trying to protect people that in fact had zero to do with anything that may or may not have been a crime that any of my friends did or did not do. You're in there, and there's no lawyer, and they ask you a question that can have 6 commas and 3 clauses and 2 tenses, and the answer depends on if it's a conditional phrase or a subjunctive phrase, and if they mean present tense or past tense. You really have to study the question to know the answer. And then there may be a legal trick in the question anyway. So you say, I request permission to leave the room and see my lawyer before I answer your question. Okay? And then he looks at you and says, why is this question different from the last question? Trying to trick you into saying something before you see your lawyer. Saying, well, this question is different because it may involve this time period. You've got to be careful. Or he will say, why do you want to see your lawyer? And you have to be, steeled up enough in this atmosphere that when he says to you, why do you want to see your lawyer? You have to say to him, I request permission to see my lawyer before I answer that question. So, you have to let yourself be made to look like an ass if you don't want to get in trouble. And you have to play these games because they play these games, but all the time, the whole grand jury, I wonder what they thought it was I was hiding. I'm sure they think I must have been hiding something. I just could never figure out what they thought was going on, especially the senile foreman. I mean, some of the people on the grand jury seemed to know what was going on. They must have been reading the Boston Globe and the New York Times. But you can't talk to them and say, ladies and gentlemen, I apologize for the time this takes you every time I go to court. But this is really a serious constitutional issue that's never been resolved. You don't want to start saying that, or you can get in more trouble with the prosecutor. I mean, I answered all the questions that were clearly involved with any possible potential legitimate investigation because I had no information. When I finally went to jail, the question I went to jail for was, name all the persons you interviewed in the course of learning who wrote the Pentagon Papers. I had very honestly testified that I knew that this study existed as far back as 1967, which is before I'd even met Daniel Ellsberg. I mean, I wasn't about to lie on that and get hooked on perjury. I said, yeah, I know there was such a study, but I wasn't interested in it because the Pentagon Papers doesn't teach you anything about Vietnam. It's only about Washington, so I didn't even bother to look into it, which in fact is true. But I found out, and now it's very clear because the whole Gordon Liddy story is out, that there were people in the White House and people in the Defense Intelligence Agency and people in the Defense Department who were waiting for the transcripts of all these grand juries to find out if there was anybody in the State Department or anybody in the Army that was leaking any kind of information whatsoever to anybody in the press at that time. And if I had said, well, in 1967, Colonel X told me he was one of the authors of the study that was then in progress, his career would have been over. And in fact, there were people in the armed services at the time I was testifying who were slated to get promotion to either full colonel or one-star general who had their promotions put off a year just in case their name came up anywhere. I mean, if anybody's name had come up in this particular investigation through me, it would have been in the most harmless and trivial way, in fact. But that wouldn't have mattered. Their career would have been over. So I had no choice but to live by what I had always thought was a very easy ethic and just go off to jail. And I was very lucky. I got a good press because it was a slow week. The issue was becoming a very serious issue that people cared about. And the guys in jail were very nice to me. A lot of younger prisoners who knew the issue and supported me, and even a few young guards who'd come back from Vietnam and had become prison guards, and were glad to know anybody who knew Dan Ellsberg. And so it was all, quite different than being in a big federal pen where things can be very, very tough. But for a year and a half, I didn't know that, and every day I had to worry about staying out of jail and being tough enough to go to jail if I had to, and maybe even worse if you're at Harvard, not going to jail unnecessarily just because everybody would like to see you do it and be a hero. Now, if I had had in front of that grand jury the same kind of elementary rights people now have in front of Congress, I don't think I would have ever been put in jail or even maybe been put through this whole ringer. When you get called in front of Congress now, you have to be told the subject of the investigation. You are absolutely allowed to have your lawyer present with you. You never have to testify without a lawyer. And you can challenge the questions you're asked. You get none of that automatically with the grand jury. Judges can do it sometimes, and they did throw out some of my questions, but the laws really aren't set up that way yet. See, nobody's ever bothered much with the grand juries because until this recent administration, they've been used to go after mafioso, corrupt Teamster officials, and things like that. And we've all sat back on our fat rear ends and applauded when they put these guys through it. And as much as I hate them for what they've done for me, I don't even think people like Colson and these guys should have to go through this. I mean, it seems to me it's intolerable that you don't have even the most simplest rights, whether you're a scholar, a journalist, or just a plain ordinary guy in the street. And I just feel that one of the important ways to get everything under control for the press, I mean, part of it has to be controlling the grand jury. Shield laws are going to be important, but a big part of our problem would be solved if we could simply get the grand jury in check, because that's the way that you go after people. The Nixon administration uses the grand jury because the FBI can't do it the way they used to, and neither can congressional committees. So when they want something, they're the last tool left in America for torture, intimidation, and chilling effects is the grand jury. And these worst abuses, not all of the abuses, and there's still going to need to be special protections for some people, reporters doing very tough, tricky work, or a few scholars. Not so much people like myself who do foreign policy, but people, let's say in sociology, who study deviance, where a lot of things they study are in fact crimes, or people who study drugs, or urban government, or an awful lot of things that really don't play by the law. Now, these people are going to need some protection. But if all grand jury witnesses had the same kind of elementary rights that they have in front of, say, the Securities and Exchange Commission or in front of Congress, things would be much better. And I mean the really elementary rights, rights like the right to know why you're being questioned, the right to have your lawyer, the right to know the relevance of the questions. And finally, let me remind you as a last point, how important it is. I mean, there's a big journalism school here, and there's a lot of debate in the state of Iowa, and there's some very people here in the state really concerned about the issue, like Senator Hughes. So there's no need, to talk to the converted about the importance of a free press, especially at this very minute where the Washington Post is getting vindicated with a Pulitzer, and even Ziegler is having to give sort of a half-baked apology to them. But there's one thing we've been forgetting the whole time this issue has been in front of us. When we say, well, obviously it's a good thing to have the First Amendment secured. Obviously it's a good thing to be able to read in the press about Watergate or about corruption or about scandal. Where's the trade-off? Who could challenge it? And there is a trade-off. And the trade-off is the kinds of things we're doing today to stop crime. Just like we did an awful lot of things that we're now ashamed of in the 50s when we were afraid of Russia. We're doing a lot of things today because we're willing to try anything to stop crime, even if there's no evidence whatsoever that it will do any good. Nobody will ever deny that there is not a very serious problem in this country with law and order. When you take a Harris poll and you find that in the major American cities, 1 out of every 3 persons belongs to a family directly touched by crime in the last year, you can't say it's paranoia. I mean, there's a real problem. But the kinds of things people think they're doing all the time to stop crime, which in the end don't make any difference anyway, give prosecutors the powers they use against political dissidents, against scholars, and against journalists. Until we have an effective approach to law and order which does not threaten civil liberties, our civil liberties are in danger. This country simply cannot survive for long in its present form if people think that there is a choice between safe streets and the Bill of Rights. Thank you. Questions? The question was, how much of this can be solved by law and how much of this will be solved by constitutional amendment? Law is part of it. I don't think an amendment is any part of it at all. And let me say one thing. The grand juries is in the Fifth Amendment. And I'll be damned if I'm going to touch the Fifth Amendment these days. I mean, I'd rather stick with the grand juries and go to jail every once in a while than to take a chance on getting a vote today on the Fifth Amendment. I mean, you know, let's leave well enough alone there. One thing, the Supreme Court is, you know, I don't think they realized what they were getting into when they passed the Caldwell decision. Since then, there is the tiniest inkling in a few circuit courts and even in the Supreme Court that they're going to give back to the press and to people who do research a little bit that they took away. There was just a case this week where the Supreme Court ruled that in a civil suit, a reporter does not have to give his information, a suit in Illinois. If I had been in the Ninth Circuit in California, which is usually, in fact, a very conservative circuit, I wouldn't have gone to jail. My circuit said I had to go to jail because the names, how I found out who wrote the Pentagon Papers might conceivably be relevant in some vague sense to the investigation. The Ninth Circuit in California, in a recent, very, very wonderfully written opinion involving some journalists with, in fact, it was a Black Panther case, some black journalists working for the Panther paper, said very, very explicitly, when the First Amendment is involved, we are going to demand that the government proceed with a scalpel and not an axe. And they threw out just a huge number of questions and said they would simply not allow those questions to be asked of those reporters. And that puts that circuit court into conflict with my circuit court. Eventually, the Supreme Court is going to hear these cases, and I think given the way Judge Powell wrote a concurring opinion in the Caldwell case, there is some chance that slowly, within a few years, when the immediate heat is off, that the Supreme Court will give a little bit back. And that, plus the laws which will make it less legitimate to attack the press, plus Watergate, which gives every reporter or somebody a way to say, you're just trying to cover up another Watergate, might mean that we might get out of the worst period very soon. I mean, until recently, I was very, very pessimistic indeed.
Drawing from your experiences with the grand jury, what would you suggest a possible way to check the grand jury? Like having lawyers, something like that?
I think one thing is there's just absolutely no reason that you can't have a lawyer there. The other thing is starting to happen. Once grand juries started going after people besides Teamsters and mafioso, the Civil Liberties Union and the Lawyers Guild and a lot of the bar groups started to finally really take notice of the grand juries. There's been just an awful lot of talk in lawyers' forums and judges' forums about grand juries. And soon, judges are going to stop saying, I really don't want to have anything to do with the grand jury and I'll leave it to the prosecutor. There's just an awareness being built up in the right places very slowly that grand juries can be misused and are very dirty. And this awareness, plus the right to have a lawyer in the room, the right to know why you're being, sort of the exact same things you have in front of a congressional committee. That would be a good start. No more questions?
What would you say if you were asked to be on a grand jury?
I would absolutely accept if I were asked to be on a grand jury. I would give anything to be on a grand jury. I have several different fantasies about being on a grand jury. I've had them several times, and they're even in color. I don't know if I can tell you all of them. You know, one of them is, well, they all involve having what's called a runaway grand jury, which every 40 years, somebody on a grand jury gets up the guts to throw out the process. You know, I guess the last time it happened was Minneapolis in the 30s. A grand jury hired its own investigators and handed down its own indictments and cleaned up the city. It happens about that often. But I'd get in there, and I think the first thing I'd do was I'd subpoena a random sample of judges and big businessmen and lawyers from all over the country and just put them through the process on any Mickey Mouse grounds whatsoever so they'd know what it was like to appear. So they'd be much more sensitive to it. That's one fantasy. Another one is getting some of the people who got me. I mean, it's not clear, but I would never turn down the chance to be on one. I hope I'd be a little nicer than they were to me. My grand jury was, with I think 2 exceptions, everybody was over the age of 40. There was one young guy who looked like he was in his late 20s or very early 30s, and there was one woman in her 30s. The rest of the grand jury looked like elderly people, between 50 and 65. There was not a single black. Now, it's supposed to be a random selection. And of course, just like juries, a lot of this is due to the fact that people beg off. But also it's due to the fact that the selection process is very, very loosely administered. And it's just now that people are bringing cases demanding fairer grand juries or blacks on grand juries if they're indicting blacks in the South, for example. Like we found after, when the Spock trial was bought against Dr. Spock and the others in Cambridge, one of my lawyers was a lawyer in that case and was a very good friend of the local federal marshal. Not the attorney, but the marshal. Just a very nice, sweet, middle-aged Irish guy. Really a nice guy. And he said, tell me, how come in the grand juries before this case there was never, ever a single woman under the age of 50? He said, oh, because I just figure I wouldn't want to take them away from their kids. He was doing this to be nice. It wasn't political. I mean, there's just all these ways that people keep large groups off grand juries. Sir?
Given the nature of grand juries and also the number of exclusions that are possible serving on a grand jury, number one, do you feel that you were in fact tried by a jury of your peers?
Well, I'm not supposed to be being tried. Wait, number 2. I'm sorry, give me number 2.
Do you think that in a trial by a regular jury, a pettit jury, that you would be tried by a jury of people who are indeed your peers? And 2, is there a real future in the jury system if you are not being tried by people who are your peers because your peers can get out of it?
Well, let me answer the question a little bit differently than you asked it, because the one you asked is more important and I'm less qualified to ask it. And I'll ask about one part of it, which I'll just take off from it, is about the difference in a grand jury and a regular jury. A regular jury, at least there are standards of evidence which apply, and there is a judge and there is a lawyer. So, at least in a courtroom, certain standards of admissibility are adhered to, and there's not as much monkey business and torture going on. In the grand jury room, you're just pretty much at the mercy of the prosecutor. So I feel that there's certainly more future in a pettit jury than there is in the grand jury.